Hey, welcome to the Disability Expert Podcast. I am Chad Brown. I'm your host, back with the trusty partner, Aaron Dalton. How you doing?
Good. Glad to be back.
Dynamic duo of disability law. So we need to get some capes. All right. We're going to get into gig economy jobs in episode 2 and how they're actually evaluated. We're going to go through some examples and some samples. But before that, I think the big takeaway is you can't understand how gig economy or side hustle jobs are going to be evaluated by Social Security Administration without an understanding of self-employment. So let's just stop for a second and let's go through and explain the self-employment rules to people so they can understand how the court is going to evaluate their self-employment. So start with, talk a little bit about step 1 of the sequential evaluation process in SGA, because that's really sort of where it's not the only way it impacts it, but it's the biggest impact that we see. So let's just give people a little refresher on SGA, and then we'll jump into how SGA is sort of factored in self-employment context.
So SGA is substantial gainful activity, and essentially it's the amount of money per month that Social Security considers to be full-time work. So for 2026, that number is $1,690 per month. For W-2 work, it's really easy to see if we're going to fail at step 1. We just look at the earnings. If the earnings are over $1,690 a month and there aren't any exceptions,
Right.
You lose at step 1. The judge doesn't even get to look at your health conditions, your medical impairments. They just say, oh, you're over SGA, denied.
Yeah. And there are some ways, like it can be reduced by impairment-related work expenses, and if you work over extended period of time, there's averaging that comes into place. But generally, what we're telling people is, look, SGA step 1 of the process. They look at an amount. If you're a W-2 employee, we look at how much you make gross on your W-2, and we sort of make an assessment. Self-employment, completely different animal.
Completely different.
So give people the framework generally of how the Social Security Administration is going to look at self-employment work in your disability case. And then we'll dive into the actual tests that they use to determine if you're going to get disqualified for SGA.
So big picture, how I usually explain it to clients is for self-employment, Social Security is not just looking at SGA. They're trying to figure out big picture, how much are you actually working? How many hours are you putting in? The joke I usually tell is Social Security doesn't care if you're a good business person.
Right.
You can be working 40 hours a week and losing money,
right.
But Social Security is interested in the 40 hours a week part. So they've implemented these 3 tests that we're going to talk about to sort of help tease that out a little bit.
Yeah, I think one of the things that's easy, it's just immediately comes to mind is this issue of whether your business is profitable or not is not the question, because almost every person we talk to who's in a gig economy job says, well, I lost money, or, in my tax return, I showed I only made $2,000, but that's not the issue. So just stop, full stop right there. Understand if you're in a gig economy or self-employment scenario, Social Security Administration by and large does not care what you file on your tax return in terms of how much money you actually took home.
Right.
Yeah. So what do they look at then? How do they make these decisions? What's the actual test?
So the first test is probably the most common one that we run into, significant services plus substantial income.
Okay. So what's all that mean?
So this test, the substantial income part is just SGA. Are you making $1,690 a month or more in 2026?
Okay.
The significant services gets a little bit more complicated. So if you're the only person working at your business, by definition, you are performing significant services. You're the only person that's making things run
right
in that business.
Yeah. So someone who works for themselves in a gig economy job as an Uber driver is almost definitionally going to have significant services.
Yes.
So under test 1, because I think there's 3 tests they go through, under test 1, you're going to be looking at, okay, do they provide significant services, and did they earn over SGA?
Yep.
They just do a very sort of black and white analysis for self-employed persons. And if you are not providing significant services, not the case usually, or you're under SGA, then you don't get denied at that step.
Right.
Okay.
And just to follow up on that, I think good example for this one is what significant services are not. So sometimes I have clients who have questions about, maybe they have a duplex and they rent out the other half of the duplex.
Right.
Typically, Social Security is not considering passive income from prior investments. Maybe when you were working, you invested in some rental properties or something. Typically, Social Security is not looking at that as significant services because it's passive income.
Well, what about like if you're in a partnership, for example? Let's get away from gig economy for a minute because we're really just talking about self-employment. So what if, frequently we find husband and wife partnerships where the husband and wife own the business together? How are they going to evaluate significant services in that context?
In that context, Social Security might look at, well, did you step back from your duties and now your spouse is running the show essentially? And so documenting that, sometimes there's even like a partnership agreement or something where you're putting in writing, hey, I'm stepping back.
Yeah, I think the takeaway though is with significant services, if you're self-employed and you're the only primary employee, you're going to meet the threshold. Otherwise, it's going to be very fact specific. It's very difficult for me to talk to someone sort of generically about significant services who is an owner in a company where there's multiple owners. Most common we see are husband and wife who sort of they own the company together. They file their taxes jointly. But generally, though, the test is significant services plus SGA. And if you have significant services and you're over SGA, then they're going to determine that you have SGA, and it's going to be a step one denial.
Exactly.
Okay, so what's test two?
The next one is the comparability test. So in this test, Social Security is looking at the job that you're doing for yourself. Is that similar to how people without disabilities do the job in your area?
Okay, so what would an example? So walk us through a little more specifically. What's sort of an analysis of how's that going to play out in real life?
So going back to gig economy work, if we're looking at somebody that's driving for Uber, for example, Social Security might look at, how many hours a week does a taxi cab driver spend?
Right.
And if you're close to that, even if you're losing money because, the job isn't paying well or your insurance is so high or something, you could still fail under the comparability test because Social Security could say, oh, well, you're driving 40 hours a week for Uber. That's the same amount of time that somebody driving for a taxi cab company or something.
So literally they're going to compare comparability. They're going to compare what you're doing to someone else in the national economy who does that job, typically in a W-2 capacity. And how about income there? Because in test one, they're looking at significant services plus substantial income. Is there an income analysis at all in the comparability test?
There's not an income component here. It is just looking at
Oh.
essentially the hours and the job that you're doing.
Yeah, and we're going to get into in episode 2 where we walk through some examples of how this plays out in the gig economy. But historically in dealing with self-employment, the comparability test is a huge problem for self-employed individuals.
Yes.
It's typical that the person who is self-employed is not in some unicorn job. Like they're doing a job that, thousands or hundreds of thousands of people in the national economy do on a regular basis. It's very easy to go in and look at that work and say, well, this is what a hairdresser who works at Supercuts does. This is their job responsibilities. This is what the hours they work. This is what a cab driver looks like. This is what a carpentry assistant looks like. So they look at it and say, well, if you compare it to these jobs, it looks like you're doing the same job. Boom, not disabled.
Right. And we can lose, 15, 20 minutes of a disability hearing trying to tease out the comparability test. And so the judges, this is something they pay a lot of attention to.
Right.
And we can actually end up spending a lot of time talking about this at the hearing when really we should have been talking about what's wrong with you.
Yeah, I mean, certainly it's important to the judge because they have to get through step one of the sequential evaluation process.
Exactly.
It's important to you because you have to get through step one of the sequential evaluation process. But I'm not going to get into it now. But in these gig economy jobs, there are some good strategies, though, that sort of, I think, debunk sort of generic theories of comparability that judges want to cling to. I think judges typically in the comparability test are going to oversimplify
Yes.
the comparison and run to a, well, this is comparable, therefore you lose. But the reality is comparability is way more nuanced than I think sometimes the administration or judges look at it in terms of their evaluation. So, okay, so we have the significant services, substantial income. We have the comparability test. What's test 3?
Test 3 is worth of work. So in this one, we're looking at, would an employer pay somebody at the SGA level to do this job?
Okay, so what's an example of that? How does that work?
So for this one, we could be looking at you're doing the job 40 hours a week, you're losing money, but could you do the job for somebody else and make SGA, essentially? Could somebody else hire you to do the job as you're doing it and you be above SGA?
So when you're looking at worth of work, what they're doing is going out into the national economy, and similar to the comparability test, they're finding someone who has a comparable job, but rather than just evaluating whether the job is comparable or not, they're looking at what you would make if you were working in that job. So while the comparability test in and of itself doesn't have an income requirement or analysis that's done, when you get to the worth of work test, in many respects, that's exactly what you're doing. You're looking at the income you would make inside a comparable job. So for example, if you have a hairdresser and they're working at in their home salon there in the back of their house, they're going to go and look and say, okay, well, let's say you were working at Supercuts, and the national economy, the average income rate, the average hourly rate for a hairdresser in one of these large sort of chain outfits is, let's just say, it's $15 an hour, and you're working 30 hours a week. So basically they take 30, they multiply it times 15, they multiply it times 52, and there you go. That's what your average annual income would be. Divide that by 12, and we're going to see, are you either over SGA or you aren't. In my experience with self-employed people generally, and certainly in gig economy jobs, this is a huge hurdle to getting on disability for people that are self-employed.
Yes, and I think test 3 particularly can be harmful for people with skilled past work histories. Maybe somebody who was in accounting or a freelance editor or something like that, where they can still do a little bit, but the hourly rate in the market is so high, it doesn't take very many hours to get to where you'd be over SGA.
So if you're working and the average landscape person makes $12 an hour and you're working 20 hours a week or whatever, I mean you're not going to get to SGA. But if you're you were an accountant in the past and now you're just handling a few select clients and you're working 20 hours 20 or 30 hours a month, but your hourly rate's $100 an hour, all of a sudden you've got a real problem under the worth of work test, because the value of what you're doing often far exceed SGA. Okay, so there's two other things I want to just hit very quickly. One is the countable income test is looking at both pre-disability finding and post-disability finding. We're not going to talk about this at all today, but there are a different set of rules once you become disabled.
Right.
And all the things we've been talking about are basically for people who are applying for disability or trying to get disability benefits. But once you actually obtain benefits, the test does change.
Yes.
Yeah, we might talk about post-approval work in some other episode. I don't know. We'll keep that in the radar. But that's not what we're talking about today. But just understand there is a different set of rules for people once they obtain benefits. The other thing, though, you have to keep in mind with unsuccessful, with self-employment work is there are still unsuccessful work attempt rules.
Yes, there's an off-ramp.
Yeah, there is sort of an off-ramp. It just depends if you could identify it clearly that the client actually took it. But just talk briefly, what are unsuccessful work attempts and how do they play into this self-employment analysis?
An unsuccessful work attempt is a work attempt that lasted less than 6 months. that was preceded by a significant gap in employment and ended due to the medical conditions. So to kind of break that down a little bit more, if I'm going to make an unsuccessful work attempt argument, what I'm looking for is, was this person out of work for at least 30 days before the unsuccessful work attempt?
Right.
Okay, good. Did the work attempt last less than 6 months? Check that box. And then we ask, why did the job end? And more often than not, the job ended because I couldn't do it anymore due to whatever medical conditions I'm applying for disability.
But with the unsuccessful work attempt, you have to understand, like, if you just sort of slow down your work and you never really stop, we have issues. If you extend beyond 6 months, we have issues. And if you just stop because you realize you're coming up to 6 months and you learned on a podcast that there was an unsuccessful work attempt, like, that doesn't fly either, which is, why with our current clients, when clients want to go back to work, and we don't tell people not to work, honestly, in our firm, because if you can work, you're better off being on disability. And then there's all other factors that go into. We did a whole episode on whether you should apply for disability or not. So go check that out. We talk a lot about sort of the mental components that go into people dealing with this. But you have real issues for people who don't ever stop work and they just sort of slow down. And yeah, I don't know. There's just a bunch of issues there. But understand, there is a whole set of rules that deal with sort of failed work attempts. They do apply in self-employment scenarios. So you got to be aware of those as well. All right. Okay. That's self-employment.
Self-employment.
Golly, we probably could do more on self-employment, but I want to get to gig economy jobs. That's going to be part 2. So join us for part 2, where we're going to actually go through and look at these gig economy jobs in light of the self-employment rules. And understand, you got to master these self-employment rules before you can ever do a true evaluation of a gig economy or a side hustle type job. But that's going to be next time. Subscribe, follow us, and until next time.